Welcome to the Deep Dive, your shortcut to staying genuinely informed. We pull out the key insights from a whole stack of sources for you. And today, we're jumping right into a topic that touches every single one of us, our personal data and how it moves around this totally globalized world. Now, this deep dive is brought to you by ProcSolve. They're experts in helping businesses handle the complexities of data privacy, specifically vendor management and data processing agreement services. You'll see how central that is as we get into it. Just think for a second. Your data is crossing borders constantly, right? But it's definitely not the Wild West out there. So what does it really take for organizations to protect your information in this, interconnected landscape? And maybe more importantly, what happens when they mess up? Our mission today is to unpack these tricky international data privacy laws, look at the frankly shocking costs when things go wrong, and exploit the strategies companies need to adopt to stay compliant and keep data safe. We're talking huge financial stakes. You might have seen headlines like Meta getting hit with that massive $1.2 billion fine over data transfers. So yeah, let's get started.
Okay, trying to navigate data privacy laws globally. It feels a bit like trying to solve a giant maze, doesn't it? It's instantly clear there isn't just one rule book everyone follows. How different are we really talking here between regions?
Oh, it's incredibly diverse. You're right. When you look at the main players, the first one that probably springs to mind is the GDPR, the General Data Protection Regulation over in the EU.
Right, GDPR, the big one.
Exactly. Then here in the U.S., you've got the California Consumer Privacy Act, the CCPA, and its update, CPRA. And we're also seeing, significant movement in Asia, particularly with India's Digital Personal Data Protection Act, the DPDPA.
Okay, so GDPR, CCPAC, PRA, and DPDPA, those are the big three we're focusing on. If you had to pick the most striking difference for someone listening thinking about their own data, what would it be?
I'd say the core difference, especially when you look at consent models, boils down to a pretty fundamental philosophy shift. GDPR is all about explicit opt-in consent before they can even collect your data.
So they have to ask permission first, clearly.
Precisely. It's a proactive yes from you, building trust right from the start. CCPA, on the other hand, generally allows companies to collect data, but then gives you an opt-out mechanism specifically for the sale or sharing of your personal info.
So it's more like, we're doing this, but you can tell us to stop selling it later.
Kind of, yeah. You have the right to say no thanks after the fact. Though I should add, CCPA does require explicit opt-in for sensitive data or for data belonging to minors, so it's not entirely opt-out.
That's a really key distinction, asking permission versus offering an exit route. Does that difference carry over into why companies are allowed to use your data in the first place?
Absolutely it does. That brings us to what are called the legal basis for processing. Under GDPR, an organization needs one of 6 specific, lawful reasons to process your data. Things like, you gave consent, or it's necessary for a contract you signed, or they have a legal obligation.
6 specific reasons, okay.
Now, what's interesting is India's DPDPA also relies on consent, or something called legitimate uses. But, and this is important, it doesn't include contractual necessity or the broader legitimate interests concept as legal basis in quite the same way GDPR does.
So just because it's part of a normal business deal doesn't automatically make it okay in India like it might in the EU.
Exactly. It narrows the justification compared to GDPR in some respects. It really highlights how you can't just apply one region's rules everywhere.
Got it. So the why varies. What about the what? How broad is the definition of personal data that's actually protected?
Well, the scope of data protected is pretty broad under both GDPR and CCPA. Basically anything that can identify a living person. But the CCPA has specific carve-outs. It exempts data that's already covered by other U.S. laws, like health data under HIPAA or financial data under GLBA.
Okay. So it tries not to double up on regulations where they already exist in the U.S.
Right. It avoids some overlap within the U.S. legal system.
And these rules, they don't just apply to companies physically located in Europe or California, do they? Like, what if I'm sitting here in Chicago using a service based in Ireland?
No, absolutely not. This is where the jurisdiction piece gets really complex and global. Both GDPR and CCPA have what's called extraterritorial reach.
Meaning they reach outside their borders.
Precisely. They apply to organizations anywhere in the world if they process data belonging to EU residents for GDPR or California residents for CCPA. Doesn't matter where the company itself is based. So a company in Tokyo processing data of someone in Berlin, they need to follow GDPR. It's a global net.
Wow. Okay, that really changes the game for international business. So what happens if a company gets tangled in this net and doesn't comply? Let's talk enforcement and fines. I've heard the potential numbers are Well, kind of terrifying.
You heard right. They can be truly massive. GDPR penalties are the most famous for this, up to 20 million or 4% of the company's total worldwide annual revenue, whichever number is higher.
4% of global revenue? That could be billions for some companies.
Easily. Now, CCPA fines seem lower on the surface, up to $2,500 for an unintentional violation,
Oh.
$7,500 if it's intentional or involves kids' data. But, and this is a huge but, CCPA includes a private right of action.
Meaning regular people can sue?
Exactly. It allows you, the consumer, to sue for statutory damages if your unencrypted personal information is exposed in a breach because the company failed to maintain reasonable security. So even if the regulatory fine isn't billions, the potential cost from class action lawsuits can be absolutely enormous.
Okay, we've sort of mapped out this complex legal landscape, but let's shift gears. What actually happens when an organization messes up? When they fail to follow these rules? You said the costs are huge, but it's more than just fines, right? Let's really try to break down that risk.
Oh, it's a massive financial hit. The very latest data from 2024 shows the global average cost of a single data breach shot up 10% to USD 4.88 million. That's the biggest jump we've seen since the pandemic started.
Almost $5 million on average, globally.
Globally. And the United States, we consistently lead the pack. The average breach cost here is a staggering USD 9.36 million.
Wow, nearly double the global average. Where does all that money actually go after a breach? It can't all be fines.
No, not at all. A really big chunk, about USD 2.8 million on average in 2024, comes from just two main areas. First is lost business. That's everything from system downtime stopping sales to customers leaving to just the long-term damage to the brand's reputation.
Right, the trust factor.
Huge factor. The second big chunk is all the post-breach response. Think about setting up call centers, paying for credit monitoring for affected people, legal fees, forensic investigations, and yes, those regulatory fines we talked about. It's the cleanup and the fallout.
It's a long tail of costs then. What type of data being breached drives up these costs the most? Is it financial data?
Actually, the most common and the most expensive type of record lost is customer personal identifiable information, PII. Nearly half of all breaches, 46%, involved PII. And losing a single PII record costs an average of USD 183 in 2024.
PII, so that's things like names, addresses, maybe social security numbers?
Exactly. Tax IDs, email addresses, phone numbers, home addresses, the stuff that lets criminals commit identity theft. After PII, intellectual property was the next most common target, involved in about 43% of breaches.
And how are the attackers actually getting in? Is it super sophisticated hacking?
Sometimes, but the two most common ways are depressingly simple. Phishing attacks, tricking employees into giving up credentials and using stolen or compromised credentials that were perhaps leaked elsewhere.
So the human element is still a major weak link.
Definitely. And breaches that start with stolen credentials, they take the longest to even find and fix. The average was 292 days in the latest reports.
292 days, that's almost 10 months. An attacker could be inside the network for that long before being stopped.
Potentially, yes. It's a huge window of vulnerability. And it's not always malicious outsiders either. While hackers cause 55% of breaches, about 23% are due to IT system failures, glitches, configuration errors, and another 22% are just straight-up human error, accidental mistakes.
So nearly half aren't even intentional attacks. That's sobering.
It is, and it highlights internal risks. We also need to talk about something called shadow data. This is basically data that exists in places the company doesn't officially manage or even know about. Maybe old databases, unsanctioned cloud storage.
Data hiding in the corners.
Pretty much.
Yeah.
And breaches involving this shadow data, they cost more, an average of USD 5.27 million, which is over 16% higher than breaches without it. And they take longer to fix, around 291 days.
Because you first have to figure out what was even lost, right? If you didn't know it existed.
Exactly. It's a major blind spot. You can't protect what you don't know you have.
That's a really powerful point. And ultimately, who ends up paying for all this? Do companies just absorb these huge costs?
Well, the data shows a pretty clear ripple effect. 70% of companies hit by a breach face significant business disruption. But here's the part that affects listeners directly. 63% of those companies said they plan to increase prices on their goods and services to help cover the breach costs.
So it gets passed on to us, the customers?
A significant portion of it, yes.
Yeah.
Unfortunately.
Okay, so given these truly massive costs and the confusing global rules, what does this actually mean for organizations? How do they even begin to safeguard data and avoid getting slammed with these kinds of hits? It sounds like they need a really solid plan.
Absolutely. It has to be comprehensive and proactive. Building a strong global data privacy framework starts with some essential steps. First off, data mapping. It's non-negotiable.
Knowing what data you have and where it is.
Exactly.
Yeah.
You need to thoroughly identify and document all the types of data you process, understand how it flows through your systems, know precisely where it's stored, paying special attention to sensitive data, and anytime you send it to a third party, like we said, you can't protect what you don't know about.
Okay, step 1. Map everything. What's next?
Then, you need strong privacy governance. This means things like appointing data protection officers, DPOs, actually writing down clear privacy policies and procedures tailored to where you operate, and setting up maybe a data privacy steering committee to keep everything coordinated.
So, people and policies.
Right. Then come the technical and organizational measures, or TOMs. These are the actual safeguards. We're talking data encryption, pseudonymization.
Pseudonymization, that's like replacing names with codes.
Yeah, basically, making it harder to link data back to a specific person without extra information. Also, strict access controls who can see what data using data loss prevention, DLP tools, to stop data leaking out, and having secure policies for how long you keep data and how you get rid of it safely.
So, tech tools and strict rules, it feels like a lot more than just a legal checkbox exercise.
It absolutely has to be. It's about embedding privacy into operations. And crucially, you need ways to facilitate data subject rights.
Making it easy for people like me to see or delete my data.
Exactly. Clear, simple processes for handling requests for access, correction, deletion. Plus, really clear privacy notices, none of that dense legal jargon, and good tools for managing consent. And finally, don't forget training and awareness.
Teaching employees not to click on phishing links.
That's part of it, yes. Regular training on best practices, running drills for how to respond if there's an incident. This is vital for cutting down on those accidental breaches. And interestingly, good training is actually proven to reduce the overall cost if a breach does happen.
That makes sense. Now, you mentioned sending data to third parties. This brings us to data processing agreements, or DPAs. Our sponsor, ProcSolve, specializes in this area. Why are DPAs so incredibly important here?
Okay, DPAs are absolutely critical legal documents. Anytime an organization shares personal data with an outside party, could be a cloud provider, a marketing platform, any vendor really, who acts as a data processor or even a sub-processor, you need a DPA.
It's the contract that governs that relationship.
Exactly. It clearly lays out the obligations and responsibilities for both sides. Now, the controller, that's the organization deciding why and how the data is processed, basically the main company using the service, they are ultimately responsible. They have to make sure the whole process is lawful and that data subject rights are respected.
So the buck stops with the controller.
Largely, yes. And here's a really key point, especially relevant given recent enforcement trends. The controller can be held legally and financially responsible for a security breach caused by their processor. If your vendor messes up, you can face the fines.
Wow. That really highlights the need for choosing vendors carefully and having ironclad agreements.
Absolutely. It underscores why you need really robust DPAs and rigorous vendor vetting. The processor's obligations are spelled out in the DPA. Only handle data how the controller instructs, implement strong security, get permission before hiring other companies, sub-processors, to help, tell the controller immediately if there's a breach, allow audits, and securely delete or return the data when the contract ends.
That's a lot of responsibility on the processor, too.
It is, and this is precisely where specialist help like the vendor management and DPA services offered by ProcSolve becomes so valuable. They help organizations navigate these complex relationships and ensure that accountability is clear across the board.
Okay, so frameworks, governance, TOMs, training, DPAs. What about just leveraging newer technology itself? Can things like AI help?
Oh, definitely. It's making a huge difference. Companies that extensively use security AI and automation see significantly lower breach costs. We're talking an average saving of USD 1.88 million compared to those who don't use it at all.
$1.88 million saved. That's substantial.
It's massive. And these tools also dramatically speed up how quickly you can spot a breach and shut it down, cutting the time by almost 100 days on average. So yeah, technology is a crucial part of the defensive strategy.
Okay, the threat of fines is clearly a big stick. You mentioned GDPR's potential for huge penalties. What does enforcement actually look like in the real world? Can you share some examples of companies getting hit?
Yeah, the trend is definitely towards more enforcement and bigger fines. Regulators explicitly state that penalties need to be effective, proportionate, and dissuasive. They look at the seriousness, how long it went on, the nature of the data, but also importantly, how much the company cooperated after the fact.
So cooperation matters.
Yeah.
Give us some of those big examples.
Well, the biggest ever under GDPR was that Meta, Facebook, fine in 2023, $1.2 billion. That was for illegally transferring data of EU users to the US without adequate safeguards. Just a monumental fine.
1.2 billion euros. Hard to even comprehend.
It really is. Then you had British Airways back in 2020, fined £20 million for a breach hitting over 400,000 customers, blamed on poor security. Marriott Hotels also got hit in 2020, $18.4 million for failing to secure data from a company they bought, affecting a huge number, 339 million guests.
And it's not just breaches, right? You mentioned Google earlier.
Right. Google got a $50 million fine from France in 2019, not for breach, but for lack of transparency and not getting proper consent for personalized ads. And importantly, on the processor side, remember how we talked about vendor risk?
Yeah, the controller being liable for the processor's mistake.
Exactly. There's the Blackbaud case in California. There are data processors for many nonprofits and universities. They got hit with a $6.75 million settlement over a 2020 breach because of their own security failures, like not deleting old backups and lacking multi-factor authentication. This directly impacted their clients, the controllers, and shows that processors themselves face serious consequences.
So the risk flows both ways, even if the controller often bears the ultimate legal burden.
Precisely. Even Sephora settled for $1.2 million in California, not for a breach, but for failing to tell consumers they were selling personal information under CCPA's definition and not processing opt-out requests correctly.
These examples really drive home the financial risks. Does having all those good practices we discussed, the frameworks, the policies, the TOMs, does that actually help if the regulators come knocking? Can it reduce the penalty?
It definitely can, yes. Data protection authorities are looking much more closely now at whether organizations have real accountability mechanisms built in. Things like established privacy programs, maybe certifications, clear documentation, transparent practices. While enforcement isn't perfectly consistent across every country or state, showing you have strong proactive measures in place can absolutely be a significant mitigating factor. It might not get you off scot-free, but it can certainly lessen the blow.
Okay, so wrapping this all up, it's crystal clear that navigating global data privacy is, well, it's complicated, it's expensive if you get it wrong, but it's just something organizations have to deal with now. It seems like having those strong foundations, the data mapping, the solid governance, really robust data processing agreements with any partners, and actually using technology like AI isn't just about ticking a compliance box anymore. It's fundamental to doing business responsibly and successfully.
Absolutely. It shifted from a purely legal or IT issue to a core strategic business imperative.
So for you, the listener, maybe the key takeaway here is that data privacy isn't just some abstract corporate problem. It directly impacts companies' reputations, their bottom lines, and ultimately, as we saw, potentially the prices you pay. Which leaves us with a final thought to chew on. As the cost of getting this wrong keeps climbing so steeply, how will organizations manage to keep innovating and growing globally while making sure that protecting your data stays right at the very top of their agenda? It's a huge challenge ahead.